Okay, good morning. Thanks very much for coming. You know, it's been so cold, and when I woke up this morning, the neuroscience question occurred to me. At what temperature will my brain start to freeze? And then I started to worry, well, what happens if it doesn't thaw out by 8:30, and I have to talk about the brain? But it's fortunately much warmer today. So if my brain does freeze, unfortunately I won't be able to move on the cold. We all hear about neuroscience everywhere now. Virtually every day there's an article in the newspaper about neuroscience. But except for the few neuroscientists that I know, I virtually don't know anyone that can tell me what neuroscience is. And I know fewer people than that can distinguish neuroscience from neurology. So if you're one of those people, let me just start off by taking on those two terms. Basically, neuroscience is the study of the nervous system, what it consists of. The brain, the spinal cord, all the nerves that control and govern our functioning, our feeling, our thinking, and the study of how that nervous system works. And neurology is the medical specialty which diagnoses dysfunctions and diseases of the nervous system and is concerned with treating those problems. But after hearing those two definitions, you might ask yourself the question, well, so what? I don't really see a big difference there. And even if there is a difference, it sounds like they pretty much do the same thing. But I think that by the end of today, we'll see that although neuroscience interfaces a lot with medicine, and the fields, in very important ways, significantly diverge. And the questions that lawyers need to pose, and juries and courts need to decide, are often answered very differently from the standpoint of neuroscience than from the standpoint of medicine. As a matter of fact, I think we'll see that in some ways neuroscience can significantly contradict the answers that are supplied by medicine to the very same questions. And we see in the courtrooms those differences and those contradictions being played out in clashes between neuroscientists and physicians, where almost invariably, from my own experience and a lot of experience in this area, it's physicians who are either volunteering or recruiting or being recruited to be on the front lines of opposing the admissibility of neuroscience evidence. I thought I would start by just talking about a few ways, and there are many, in which neuroscience can be important to the courtroom and to the law. And a really important way that occurs to me is causation. And there are causation issues that from a medical standpoint, or even a common sense standpoint, because our common sense is very much formed and informed and conditioned by what we understand about medicine. But from those standpoints, there are causation issues which would seem preposterous, or at least far-fetched. But from a neuroscience standpoint, they seem quite plausible and even probable. And this understanding came to me really early in my career, when I had a client who suffered a fracture of her wrist. And in the aftermath of that fracture of her wrist, she developed a very severe and chronic pain condition. And sometime after that, she developed breast cancer. And she was insistent that the breast cancer came from that series of events. Now, from a common sense standpoint, those things seem so unrelated. And from a typical physician standpoint, those events, the correlating of events, may seem absurd. But I was lucky enough to find my way to the University of Rochester Medical Center in their Department of Neuroscience, their Department of Neurobiology and Anatomy. And from their standpoint, the correlation was quite direct, probable, and even quite probing. We hear a lot about concussions. We hear about concussions now every single day. Now, concussion is a medical diagnosis. But I think we'll see that from a neuroscience standpoint, diagnosis is not an endpoint, but diagnosis is just the beginning of the inquiry. And although physicians are often content with, physicians often the end goal of their understanding is the diagnosis, neuroscientists have learned today to take that diagnosis, the understanding of the consequences of that diagnosis, very much further. It can help us understand in that individual patient how that concussion is changing the wiring of the brain, how that concussion is changing the communication within the brain, how that concussion over time is causing a cascade of events inside the brain that's causing that brain to atrophy, how those atrophies are changing that person and changing their decision making and changing their moral, their own self and moral guidance. It can give us insight into the changes in that brain that can give us a basis for predicting a significant probability of the specter of future dementia. None of these issues are really within the realm of medicine, and if these issues are brought to physicians, lots of times most of the time, they'll be treated as too speculative to be dealt with. And so often in the court, these issues are bypassed. But neuroscience can give us that additional understanding, and really crucial understanding, because from a lawyer standpoint, we're not really concerned ultimately about diagnosis. We're concerned about consequences, and although the additional neuroscience information may not change the diagnosis, or may not alter the treatment, it can give us a very deep window into the consequences. And the bottom line in our cases, that's what we're concerned with, showing the consequences. That may not be the medical concern, but that's the neuroscience concern. And in that way, the legal concern often coincides. It's what are the consequences? Neuroscience can also offer the opportunity to change the fact finder's attitude from condemnation to some more compassion and understanding that the conduct that's being so criticized and so vilified is not because the person in question is innately bad, but because the conduct was held by brain changes that made the conduct to some extent, or maybe to a full extent, uncontrollable. And with that insight, gives us the opportunity to implant a certain humility in the fact finder that, but for the grace of God, that person could have been me if I had those brain changes. See, the neuroscience literature shows what a significant incidence there is in brain abnormalities in violent criminals and people that are convicted of crimes. But every day now, just 2 days ago in the New York Times, or was it yesterday in the New York Times, they talked about the prevalence of violence by National Football League players. And I'm very confident that very few of those National Football League players who are involved in domestic abuse have had the type of neuroscience investigations that we're going to talk about here. And I'm very confident that if they did, the brain dysfunctions that would be detected, that aren't detected by conventional medical investigations, whether it be MRI or CAT scan or medical assessments, which show levels of dysfunction, pervasive dysfunction, that really shift in a whole different alarming and urgent gear the whole discourse about sports and concussion and the damage it's doing and the ominous consequences that are attended by those types of injuries. The same could be said for veterans from Iraq and Afghanistan who haven't had the type of neuroscience evaluations, but only had the diagnoses, neuroscience evaluations that would show the harrowing future that they're facing and their families are facing. We're also going to hear today how much can be at stake in terms of the neuroscience, the visibility of neuroscience information. And in a criminal context, it could be the difference between freedom and conviction. It could be the difference between a life sentence and a death sentence. And we're going to have people here today who have been on that front lines with neuroscience matters that much. I was thinking about some of the examples in which neuroscience differs and even contradicts medicine. And one of the main examples that came to me was the issue of pain. For the personal injury attorneys in this audience, we deal with pain in every single place. And from a medical model, pain is described as subjective, individual. In the context of the courtroom, that's a code word for probably not real and unverifiable. And that dichotomy between subjective and objective, what's real and what's verifiable, is also embedded now in our law, where no matter how severe the pain is, it doesn't count as an indicia of serious injury under our law, while even compared to a range of motion, which is much more important. So crippling pain doesn't count because it's not it's subjective, while just observational things count because that's what a doctor can see. And so every case we have is this battle, because the medicine has this dichotomy between subjective and objective. Every case is a battle between doctors contesting whether the pain is real and how severe it is and how disabling it is. But from a neuroscience standpoint, that's a subjective, objective model is really a false dichotomy. We're going to hear from a neuroscience standpoint, we'll hear a lot about that today, that although pain, the experience of pain is individual, and that's subjective from that standpoint, that subjective experience can be objectively demonstrated. It can be objectively demonstrated by functional MRI, which evaluates blood activation in parts of the brain activated when a person's in pain. It can be demonstrated by electrical testing of the brain from an electrical standpoint. And the brain is an electrical organ. Can also evaluate that brain activation from parts of the brain that become activated in chronic pain. So neuroscience collapses that distinction. And neuroscience kind of gives us insight that when doctors discount pain as being only subjective, what's really being said is that it's not inside their own toolbox to confirm that pain. Another difference in the way that physicians look at pain and neuroscientists look at pain is that from a medical standpoint, pain is a distress, and the job is to alleviate that distress. But from a neuroscience standpoint, whatever that pain diagnosis is, pain is so much more. Chronic pain, chronic severe pain, is a corrosive disease, a disease that can atrophy the brain, and in the course of atrophying the brain, degrade all sorts of functions that in the brain that are supported by those affected parts of the brain. So to give you an example, take sciatica. From an orthopedic standpoint, or from a neurological standpoint, so sciatica is pain shooting down the leg. But from a neuroscience standpoint, chronic sciatica, untreated sciatica, is a potential brain injury that can atrophy parts of the front of the brain, certain relay networks in the brain, just as if the brain had been actually traumatized, with all sorts of terrible consequences. This neuroscience is not compartmentalized like medicine, so it's not limited to its own department of neurology or department of orthopedics. The body isn't limited by a department of orthopedics and department of neurology or department of immunology. Neuroscience is concerned with the entire integration of our being. Another example of how physicians look at pain and neuroscientists look at pain is the issue of placebo. So for trial lawyers here, We've heard about the issue of placebo used to discredit plaintiffs' complaints of pain. And so from a medical standpoint, the placebo is an imagined effect of an intervention or a pill. As we hear today, from a neuroscience standpoint, that's just not true. That from a neuroscience standpoint, the pain alleviation from a placebo is as much a real biochemical phenomenon as the chemical effects of the pill that the placebo is being compared to. We also hear today from criminal attorneys, and in many criminal proceedings, the issue is the testimony comes from psychiatrists whether the defendant has the capacity to know the difference between right and wrong. But from a neuroscience standpoint, that just begs the question. Because even if a defendant knows the difference between right and wrong, it doesn't answer the question whether the parts of their brain that can make value judgments about what right and wrong, that imbue the person with the ability to care about that difference, are functioning intact. Or even if they care about the difference between right and wrong, that part of the brain is working. It doesn't answer the question whether the parts of the brain that can control their conduct, regardless of what they know about right and wrong, are intact. In so many cases, regardless of their intellectual sense of knowledge, and even care about the difference between right and wrong, parts of the brain are damaged which dysregulate the person's ability to control the difference between right and wrong. So neuroscience offers the opportunity for the fact finder, instead of morally judging, morally condemning the defendant, or whoever the person being judged is, to really stand in that person's shoes. In many cases, we hear about the issue of lingering. Lingering meaning, lingering discussed by experts to talk about, to show that the person involved is faking or exaggerating. And in that regard, they perform effort testing. That's something that often is failed. And based on the failure of that testing, the inference is that the person who took the test is faking. But never in the interpretation of the tests is reference to the parts of the brain that determine the person's ability to make that. And there are parts of the brain that govern motivation. There are parts of the brain that govern effort. And so, if those parts are not working because of injury, the effort testing, which is construed as malingering, is actually confirmatory of the brain injury, rather than negating the brain injury, especially when you're comparing it to the other brain results. Many people may not know this, just to give you one more example. But the biggest, largest area of disability in the American military for veterans returning from Afghanistan and Iraq is tinnitus, ringing in the ears. And in the more extreme cases, it can be so distressing that it can make people suicidal. From a medical standpoint, from an ear, nose, and throat doctor's standpoint, well, ringing in the ears is just ringing in the ears. But from a neuroscience standpoint, tinnitus is a whole different phenomenon. Tinnitus is a phenomenon of the activation of parts of the brain, limbic system, which governs emotional activation, auditory, parts of the auditory content, the cortex, other parts of the brain. And it's that abnormal activation which accounts for that distress. And so there's this parallel universe of understanding between medicine and neuroscience in the area of tinnitus, which kind of illustrates what I'm talking about. And in that area, there's a very little interface between those understandings. Where medicine sees something in a very limited, in one way, and neuroscience sees it in a very different way. And what's really interesting, getting back to the issue of causation, is that from an ear, nose, and throat standpoint, tinnitus is a function of problems of the ear that result in distress. But from a neuroscience standpoint, that's one way that tinnitus can happen. But the biggest comorbidity in the American military is the combination of tinnitus and post-traumatic stress disorder. And so although tinnitus can cause a lot of distress, from a neuroscience standpoint, psychic distress can also degrade relay systems in the brain, which can precipitate, intensify, and perpetuate tinnitus. So I'll give you a very brief survey of the ways, the probative opportunities that neuroscience provides us. There's another really significant side to neuroscience, which will either be implied or discussed in the course of this conference. And that is that neuroscience advances, and I think we all know that neuroscience is galloping in its advances, pose a profound challenge to legal doctrines, laws that are based on medical notions and moral notions that neuroscience is increasingly invalidating if you study that science. And so ideas about responsibility, and intention, sanity, culpability, causation are going to have to be reconceptualized if our law or adjudications be perceived as based on our best and current knowledge. Because if they're not, it impugns those adjudications and impugns our laws. In the area of causation, since neuroscience has such a more sophisticated and complex idea about causation, there's a significant potential that activities and products that from a medical standpoint are viewed as quite safe, as neuroscience advances, can be shown to be quite harmful. And so areas of liability can be created that could be quite disruptive. Neuroscience also offers us as attorneys the opportunity to pursue a higher representation of the truth and position us with that to pursue a better quality of justice. And no matter how inconvenient that truth or how disruptive that truth, and I'm confident it's going to be neuroscience is going to be very inconvenient in lots of ways and disruptive in lots of ways to the law. It's our job to pursue that truth. I want to, so hopefully today's conference will help you do that job. I want to thank Fordham Law School very much for giving me this amazing invitation to create this conference. And I hope and I trust the all-star cast of people we have today will honor that invitation. I also want to thank in advance a lot of the neuroscience speakers who are here today, people I know very well, people who have been tremendous teachers to me over the years. Because without them, I wouldn't be here.